A very good morning to all of you. In this session, we would be reviewing your first test on law, namely the Contract Act, which a part of the Contract Act which you must have taken, consisting of what is the nature of the contract, consideration, and essential elements of a valid contract. Law is one paper which must have been new to each one of you because you must have studied accounts, quantitative aptitude, and economics in your 11th standard and 12th standard. But law is something which must have been, like totally new to you in terms of concepts and the terminologies used. So let me just give you a brief about this subject before I take this forward and start reviewing the questions. From a chartered accountancy point of view, law is an extremely important subject because apart from accounts, law is one paper which is prevalent in your CPT, which is the entrance, the IPCC, the intermediate, and the final. So you would have law paper in all three stages of chartered accountancy, and this is an ample evidence for you to understand the importance of this subject. From a CPT perspective, law is combined with accounts to total up to 100 marks, where law would be for 40 marks and accounts would be for 60 marks, making up the first paper, and quantitative aptitude and economics would be the second paper, sharing 50 marks apiece. So essentially, law would constitute 40% of your paper 1, and it comprises of 3 acts, which are primarily the Indian Contract Act, the Partnership Act, and the Sale of Goods Act. Syllabus wise, it is not very complicated because we are just talking about three acts, and your level of knowledge required is also not very deep. You just need to have some basic knowledge about these 3 acts. Looking at the past track record, law is a scoring subject for each one of the students. So if you are able to understand the basic concepts in law, you can expect a high score, and scores close to 37, 38 out of 40 is very much possible. Considering the limited syllabus and the fact that it is combined with accounts, students can look forward to scoring very high in paper 1, which is the accounts and law paper, and hence please take law seriously, not only for this but from a long-term perspective also. As far as economics and quantitative aptitude is concerned, you might not need them once you have cleared your CPT, but accounts and law is something which you would need continuously, and hence more focus needs to be given on these 2 subjects which comprises of paper 1. With this brief background, let's start reviewing the questions on the presumption that you must have gone through your lessons properly and then taken the test. On this premise, let me start reviewing the questions. Question number 1. When an offer is made to the public as a whole, it is called, the choices are specific offer, cross offer, general offer, and none of these. What is being tested in this question is your basic knowledge on the different types of offer. When an offer is made to the public, it is a general offer, and hence answer to this question is C. In case of a general offer, any person performing the conditions of the offer is deemed to have accepted the offer. The general offer can be withdrawn at any point of time before it is accepted by any person. So the answer to this question is general offer. As the name implies, specific offer is made to a particular person or group of persons. Cross offer is one where you make an offer and the other person also makes an offer to you without knowing that you have already made an offer, and none of these anyway is not the choice. So the answer to this question is C, general offer. Coming to the second question, the object of the contract. The knowledge that is being tested is what are the various essential elements of a contract. We all know a contract has to be legal and lawful, and hence the answer to this question is C. Now you might get a doubt as to what is legal and what is lawful, because for a common man both may signify the same. There is a difference between legal and lawful, because an unlawful act attracts civil sanctions, whereas an illegal act attracts criminal sanctions. To give you an example, it is unlawful to build a house without planning permission, but it is not illegal to do so. So the answer to this question, the object of the contract should be both legal and lawful. Coming to the next question, an offer must be made. The choices are only for publicity, B with an intention to create legal relationship, both A and B, and option D is none of the above. Now, common sense dictates that one does not make an offer just for publicity. So you can eliminate option A, and as we have all must have studied, an offer is made to create a legal relationship, and hence the answer to the question is B, because option A is definitely not the answer, because of which option C is eliminated automatically, and option B, which clearly is the intention for making an offer. So answer to this question is option B. Going to the next question, which of the following statement is true? An agreement is an unaccepted proposal. An agreement enforceable by law is a contract. An agreement can only consist of an offer. And D, an agreement can only consist of an acceptance. The answer straight away is option B, because we must have all studied the basic explanation for an agreement is, or for rather for a contract is, any agreement enforceable by law is a contract. Now let us look at the other options. An unaccepted proposal, you can never have an agreement, because agreement essentially means a contract between two people. So an unaccepted proposal means just a proposal has been made which has not been accepted by the offeree. So A cannot be the answer. Similarly, an agreement can only consist of an offer, cannot be an answer, and so an agreement can only consist of an acceptance. It should be between two parties and should also be enforceable by law. Hence, the answer for this question is B. An agreement enforceable by law is a contract, is a true statement. Going to the next question, a contract may be A express, B implied, C A or B, D A and B, which is expressed and implied. A contract, as we have seen, can either be express or implied. It is express when an offeree expressly conveys acceptance, whilst it is implied when the offeree through his actions conveys his acceptance without expressly stating it. Thus, a contract can either be express or implied. So the answer to this question is option C. Next question. In dash contract, all the parties perform then promise. This actually is a tricky question with nothing much to be tested except some logic part of it. The question says that the parties have performed, which means the contract is already executed. Hence, the answer to this option must be A, which is an executed contract. So the answer to this question is A. In an executed contract, all the parties perform then promise. Next question. Which of the following is not true? It is very important for the students to carefully read each and every word of the question, because in this case, for example, if a student is in a hurry, he might miss the word not in the question, which would totally change the meaning of the question. So the question specifically asks which of the following is not true. So we need to ensure that we read the question very carefully. To recollect the rules of acceptance, they are: the acceptance must be absolute and unqualified, it must be communicated to the offerer, it must be in the mode prescribed, it must be given within a reasonable time, mere silence is not acceptance, and lastly, acceptance by conduct. So when you look at this question, option A clearly states acceptance must not be communicated to the offerer in the choices given, whereas the rules clearly state that acceptance must be communicated to the offerer. So this is the statement which is not true, and hence the answer to this question is option A. Let's go to the next question. An offer can be revoked. We are now talking about when an offer is revoked or when it can be revoked. If you recollect the rules pertaining to that, an offer can be revoked by an offerer by communication of a notice of revocation, when the offer lapses on account of expiry of time, and before it is accepted by the offeree. So when you look at the options given in the question, by communication of notice of revocation, by lapse of time, before its acceptance is complete as against the offerer, all three are conditions or situations in which an offer can be revoked. So the answer to this question is option D, or all of the above. Next question. Agreements which do not create legal obligations can also be considered as contract. We have all seen that an agreement enforceable by law is a contract. Thus, any agreement which does not create any legal obligations cannot be treated as a contract. So in this case, the question states agreements which do not create legal obligations can also be considered as contracts is not true. Hence, the answer to this question is option C, which is false. Now going to the next question. An illegal agreement is, as we all know, an agreement again is enforceable by law, or rather an agreement enforceable by law is a contract. Thus any agreement that is not legal or rather illegal is not valid, or in other words it is void. Thus the options given in this question are: A is void, B is unenforceable by law, C is against public policy, D is all of the above. The answer is obvious. An illegal agreement is void ab initio, as we call it. So it is void from the beginning. Hence the answer to this question is option A, which is void. Going to the next question. An agreement which is enforceable by law at the option of one or more of the parties thereon, but not at the option of the other or others, is a... This question clearly talks about a voidable contract if one knows the meaning of what a voidable contract is. To give you an example, a voidable contract is one where the consent of one of the parties was obtained either by fraud, coercion or undue influence, and such a party has the right to accept or reject the contract, whereas the other party who had forced this party to sign the contract does not have this option. Thus, the answer to this question, an agreement which is enforceable by law at the option of one or more of the parties thereon, but not at the option of the other or others, is option C, which is voidable contract. Let's go to the next question. A contract was entered before 1st September 1872, is governed by the Indian Contract Act. This question tests your knowledge on the date of applicability of the Indian Contract Act. The Indian Contract Act came into effect from 1st September 1872 and hence does not apply retrospectively. Hence, any agreement entered before this date is not governed by this act. So, the answer to this question is option number C. The act does not apply retrospectively. Hence, any contract entered before the 1st September 1872, when the contract came into force, is not governed by the Indian Contract Act 1872. Next question. Tender for supply of goods is an offer which is allowed to remain open for acceptance over a period of time. Such offers are, the options given are cross offer, general offer, standing offer and unlimited offer. 1. The question tests the knowledge of the student on certain types of offer. Reviewing the various options given, it is very clear that tender for supply of goods is not a cross offer or an unlimited offer as the name signifies. There could be a confusion for a student between general offer and standing offer, and this is where the student needs to understand clearly the difference between a general offer and a standing offer. In case of a general offer, when the offer is accepted by the first person, it ceases. Whereas in a standing offer, it remains open for acceptance for a certain period of time. Thus, a tender is also a similar offer where the time available for the offeror is available for a particular point of time, and hence the answer to this question is option C, which is standing offer. Thus, the student needs to clearly understand tender for supply of goods is a standing offer and not a general offer, as one can be misled to believe so. Next question. All contracts are. This is a very simple basic question that tests the student on what a contract is. We all know a contract is an agreement enforceable by law. So, the answer to this question is obvious. It is A, agreement, because contracts are not promises or set of promises or proposals as the other options are. So, the answer to this question is option A, all contracts are agreement. Going to the next question. In the case of a specific offer, it can be accepted only. The question clearly states that the offer is specific, and as the name indicates, a specific offer means an offer that has been made to certain segment of people. Thus, in case of a specific offer, it can only be accepted by the person to whom the offer has been made. Supposing, to give you an example, X makes an offer to Y. The offer can only be accepted by Y and not by any third party or even a stranger or a legal heir. So the answer to this question is option A. In case of a specific offer, it can be accepted only by the person to whom it is made and not by any other person. Going to question number 16. An illegal agreement. The options given are is void ab initio, becomes void, void ab initio as well as punishable, and D, voidable. We all know that an illegal agreement is void ab initio, that is void from the beginning. However, we also need to remember, because the agreement is illegal, they are also a punishable offense. Thus, an illegal agreement is not only void ab initio but also punishable. So the answer to this question is option C. An illegal agreement is void ab initio as well as punishable. Going to question number 17. To make a valid contract, consideration should be available and it should also be adequate. The options given are true, partly true, false, and none of these. Strictly speaking, such options will not be given in your examination for the simple reason partly true means it is partly false also. Anyway, let us understand the concept what is being tested in the question. The question deals with two aspects. It says that to make a valid contract, a consideration should be available, which is correct, and it should also be adequate. The rules does not state that the consideration needs to be adequate, and hence the answer to this question is it is partly true, because the fact that consideration should be available to make a valid contract still applies. It should also be adequate is not necessary, so it is partly true. If a student has written the option as C, false, it is also correct, because if these two conditions are taken in conjunction, then it is not true, which is false, so it can also be false. So this was the reason why I told you such questions may not be asked in the examination, which is ambiguous. But anyway, let us understand the fact that consideration is essential for a contract, but it need not be adequate. Question number 18. X promises to pay Y rupees 5 lakhs if Y murders Z. Here the consideration is, we are clearly talking of a contract that is illegal, because we are talking about murdering a person, and murdering a person is illegal, and it is also unlawful being illegal. Thus, the answer to this option of a contract where there is a promise to pay some money if a murder takes place is consideration is unlawful because of the nature of the promise. Going to question number 19. Contract without consideration made on account of natural love and affection is. The options are valid, void, voidable and unenforceable. Section 25 talks about exceptions to the rule or certain cases where contracts can be applicable without consideration, and one of the exceptions to the rule is any agreement made on account of natural love and affection, there need not be any consideration. Thus, if you know this particular rule, then the answer is very clear. Such a contract is valid, and hence the answer to this question is option A, which is valid. Thus, a contract without consideration made on account of natural love and affection is valid. Question number 20. No consideration, no contract is the rule of the law. Again, looking at the options, we have options like partly true, which is partly false, as I had spoken earlier. Cannot be anything which is partly true. But anyway, let us understand the principle of the law. The basic rule of Contract Act is no consideration, no contract. There might be exceptions to that rule, or section 25 of the Act may list down a few cases where a contract without consideration is valid, but in general, no consideration, no contract is the rule of the law. So the answer to this question is option A, which is true. Question number 21. Consideration must move at the desire of the promiser. Hence, it is necessary that the promiser should benefit by the consideration. You need to read this question carefully. It's very clear that if you have studied the law, basically it says that consideration must move at the desire of the promiser. However, you might tend to be misled stating that the promiser should need not be benefited by the consideration. However, it is very important that the promiser should also be benefited by the consideration. So the answer to this question is option A, true. Hence, please remember that a consideration must move at the desire of the promiser, and that the promiser should also be benefited by the consideration, and hence this statement is true. Going to question number 22. Which contract will be valid without consideration? Here the knowledge on section 25 of the Indian Contract Act is being tested, where it enlists a few cases where a contract without consideration is still considered to be valid. The options given in this question are compensation for voluntary services, to pay time bar debts, and agency and contract of agency. And option D is all of the above. If one knows what section 25 of the contract states, it is clear that all three options listed, that is A, B and C, are contracts which will be valid even without consideration, and hence the answer to this question is option D, all of the above, as all these contracts will be valid even without consideration as per section 25 of the Indian Contract Act. Going to question number 23. Consideration for the benefit of third party is not valid. What does this mean exactly? Two parties enter into an agreement. There is a consideration in that contract which makes it valid, but the consideration is in favor of a third party at the behest of one of the parties to the contract. The question asks whether such a contract is not valid. Again, the confusion of partly true and false. But again, let us understand the principle. It is absolutely perfect to have a consideration for the benefit of a third party, and such contracts are valid, and hence the answer to this question is option C, false. There can be contracts where the consideration is for the benefit of the third party and the contract will still remain valid. Question number 24. All agreements made without consideration are void. Again, we are talking about section 25. It is not necessary that all agreements made without consideration are void, even though the general rule is no consideration, no contract. As we have seen, there are certain cases where agreements made without consideration are still valid. That is what section 25 talks about. Hence, the answer to this question is option B, false, as there are certain exceptions also. And what are those exceptions? Any agreement made out of natural love and affection need not have a consideration. Promise to pay a time-barred debt need not have consideration. A contract of agency need not have consideration but will still constitute a valid agreement. The list goes on like this. These are something which is given to you as an example. So the answer to this question is B, false, as there are certain exceptions to the rule no consideration, no contract. Going to question number 25. X agrees to sell coconut oil for rupees 10,000 or rupees 5,000. The contract is the basic question the basic knowledge we need to have when a contract is certainty. The agreement needs to be certain on what is being sold and for what consideration. Here, if you look at the question, it says X agrees to sell coconut oil for rupees 10,000 or rupees 5,000. The agreement does not clearly state what is the quantity of coconut oil that is going to be sold. Secondly, the price is also not clearly specified. So in this case, the contract is clearly void, and hence the answer to this question is option B, void. Because there is no certainty on account of the quantity of the oil that is going to be sold and the price, this is not a valid contract and hence it is a void contract. Going to question number 26. consideration is one of the essential elements to support. The options given are agreement, contract, offer or acceptance. We have all seen consideration is one of the essential elements of a contract. So the answer to this question is option B, contract. Question number 27. Consideration in a contract of sale of goods can also be paid partly in money and partly in goods. If you recollect what the law talks about consideration is, it states that there must be consideration for a contract to be valid, and it does not specify the form in which the consideration has to be paid. So in this question, they state that the consideration is being paid partly in cash and partly in goods, which is a barter system which was being followed in India earlier. There is nothing wrong in having a consideration like this, because all that a law specifies is that there needs to be consideration. So the answer to this question is true, because the statement is correct. Going to the 28th question, there can be a stranger to a. This talks about the doctrine of privity, where persons involved in a contract can only be able to sue in relation to a contract. So there can never be a stranger to a promise, because promise is essentially between two people. There can never be a stranger to an agreement, because again an agreement is between two people. There can never be a stranger to a contact. Contact is anyway a relevant term in this particular option. And we all know that there can be a stranger to a consideration. A stranger in this case is a third party who is not privy to the contract between these two people. Thus, the answer to this question rather is option D, which is consideration. Please remember that there can be a stranger to a consideration, as this question signifies. Going to question number 29. Which of the following statement is true? There can be a stranger to a contract. It is not possible, because a contract is an agreement between two people or between two groups of people. There can be a stranger to a consideration. We just saw there can be a stranger to consideration in the previous question. Consideration can be effected in favor of a third person. We have all seen. Thus, the answer to this question is option B, because this is the true statement in the given options. Going to question number 30. A owes C rupees 10,000, but the debt is barred by the Limitation Act. D signs a written promise to pay C rupees 5,000 on account of the debt. Choose the best alternative. So we are talking about a time bar debt being paid by another person on behalf of C, who owes, rather on behalf of A, who owes C some money. We all know, if we recollect section 25 of the Contract Act, that a time bar debt can continue or is a valid contract without consideration. Thus, a promise to pay a time bar debt is not enforceable. Option A is not right. It is not a valid contract is also not right, because it is indeed a valid contract. It is a voidable contract, which is option C. It is not a voidable contract. And option D, it says it is a valid contract. Yes, this contract is a valid contract. Hence, the answer to this question is option D. Going to the 31st question. Which of the following statement is true? Consideration, The options given are A must be of any value, B must not of the desire of the promiser, C may move from one person to any other person, D must be illusory. Straight away looking at the options, you can come to the right answer. Consideration obviously cannot be of any value. Any value means it can be anything which is not true. Must, and we all know that consideration may move from one person to any other person. We have all seen that earlier. So the answer to this question is option C. Consideration may move from one person to any other person. Going to question number 32. Privity of contract is subject to the exception. The options are where a trust or charge is created, where payment is made to a third party, where payment is made by a third party, and none of the above. Now, what exactly is privity of contract? We need to understand this. You must have read what is privity of contract, but basically one needs to understand this a little bit more clearly to answer this question. Privity of contract essentially means that in that contract no other person can be conferred with rights or can be imposed with obligations arising under that contract except the parties who are entering into the contract. To explain it a bit more clearly, let us say that a contract has been entered into between A and B. The rights and the obligations arising under the contract can only be imposed on or conferred on either A or B, and it cannot be done on any other person, for example C. This is what essentially is privity of contract, and there are certain exceptions to privity of contracts, and what such exception is, where a trust or charge is created, the beneficiary of the trust may sue the trustee to carry out the contract even though he is a third party and does not have a right to sue the other party as per the doctrine of privity of contract. In the other options given, where the payment is made to a third party or where the payment is made by a third party, these are not exceptions to the doctrine of privity of contract, and hence the answer to this question is option A, where a trust or charge is created. This is an exception to the doctrine of privity of contract, thus enabling the beneficiary of a trust to sue the trustee even though he is not a party to the contract. Now let's go to the next question, question number 33. An agreement in restraint of marriage is, there are certain agreements which we must have seen are void, and one such agreement that is void is an agreement in restraint of marriage. Thus, an agreement in restraint of marriage is a void agreement, and few examples of void agreement are where both parties are under a mistake of fact. For example, they think that a particular goods exist at the time of they getting into an agreement, but on account of an accident the goods have been destroyed, or where the consideration or object of an agreement is unlawful, etc., are examples of void agreements. And an agreement in restraint of marriage is also one such case. Thus, the answer to this question is option C. An agreement in restraint of marriage is a void agreement. Question number 34. A person who is interested in the payment of money and pays such money which another is bound by law to pay is entitled to be reimbursed by the other. Now, to understand this question clearly, let us substitute names to it. Let's say A is paying some money on behalf of B to C, and B owes C that money. In this case, the question asks whether A is entitled for a reimbursement from B because he has made that payment on behalf of B to C. The answer is obviously yes. Thus, a person who has made some payment on behalf of another person who is bound by law to make that payment is entitled to be reimbursed by the person who has not made the payment. So the answer to this question is A, true. Question number 35. Undue influence involves. You must have read this under the essential elements of valid contract: undue influence and coercion. Coercion talks about physical force being used, and undue influence talks about exerting mental pressure. Thus, the answer to this question is A, mental pressure, because undue influence involves exerting mental pressure on a person and getting something done. Question number 36. A void agreement is one which is, when we say an agreement is void, then there is no valid agreement. So option number A, which states it is valid but not enforceable, is not right. Option B states a void agreement is enforceable at the option of both parties, which is again not right because it is not a valid agreement at all. So option number C is also not right. So the answer to this question is option D. A void agreement is one which is not enforceable in the court of law. There is no standing to that. Question number 37. Which of the following agreements are opposed to public policy? The law lists certain agreements as agreements that are opposed to public policy. Let us look at what the options are. Option A, agreement to commit crime. Yes, it is indeed an agreement that is opposed to public policy. Agreement to plead bar of limitation. Yes, this is also an agreement as opposed to public policy because not supposed to plead bar of limitation. Agreements interfering with an administration of justice. Very much opposed to public policy. So the obvious answer to this question is option D, all of the above, because all the agreements enlisted in the question in options A, B and C are opposed to public policy. Question number 38. A person to whom money has been paid or anything delivered by mistake or under coercion must repay or return it. Now let's understand the question properly. Somebody has made some payment to a person either by mistake or by force. The question asks whether the person who has received the money, is he entitled to repay the money or return the money to the person who has made the payment. The answer is obvious yes. So the answer to this question is option number A, true. A person to whom money has been paid or received by either mistake or under coercion must return the money to the person who has made that payment. Question number 39. This talks about admission of a minor to a contract. The question states a minor can be admitted for. A minor, because he does not have the capability to judge and enter into a contract, he cannot be admitted to an agreement for losses. But because the reputation of the minor is good and they would want him to increase or to ensure that the business is good, in that case a minor can be admitted, but in which case he can be admitted only for the benefits and is not entitled to share a loss. Option D states that a minor cannot be admitted, which is also not right. So the answer to this question is option A. A minor can be admitted for benefits only. Question number 40. Where mistake as to matter of fact essential to an agreement is bilateral. The agreement is, we are talking about an agreement entered into by two people where the matter of the contract, the subject matter of the contract is misunderstood. To give you an example, X thinks that he wants to buy a car from Y and goes and tells him, I would like to buy your vehicle. And Y thinks that X wants to buy the motorcycle and says, yes, I am prepared to sell my vehicle. There is a mistake as to the matter of the fact from both parties. Since there is a mistake to the matter of fact from both parties, this agreement is void from the beginning or void ab initio. So the answer to this question is option C, void. Question number 41. If the seller makes use of pretended bidding to raise the price, the sale is, we are talking about a fraud that is taking place. A seller pretends as if there are multiple bids taking place to increase the price. Then it's a clear question of fraud. Hence, the sale is clearly void. And thus the answer to this question is option number A, void. Let's go to question number 42. Which of the following is true? The first option is, ignorance of law is no excuse. We have all studied the term which clearly states ignorantia juris non excusat, which in other words means ignorance of law is no excuse. So the right answer to this question is option A, ignorance of law is no excuse. Question number 43. A minor is liable for necessaries supplied to him. A minor's liability for necessaries supplied to him. At what stage is a minor liable for necessaries supplied to him? The options are, the liability arises after he attains majority age. This will definitely not be the right answer for the simple reason a person attains majority age when he completes 18 years of age, and we do not know at what stage are we talking about necessities being supplied to him. So the option A is not right. It does not arise after he attains majority age. Is against only minor's property. Now the key term in this question is, we are talking about liability for necessaries and not liability for luxuries. Thus, if any necessary item has been supplied to a minor, the minor is responsible and is liable to pay the same from his property. So the answer to this question is option number B. A minor's liability for necessaries supplied to him is against only minor's property. If the minor's property is insufficient to pay the debt or the liability ceases to exist, and the person who had extended this facility will not get anything more than what the minor's property can provide for. Going to question number 44. An agreement is void if it is opposed to public policy. Which of the following is not covered by the heads of public policy? The options given are A. Trading with an enemy, which is definitely opposed to public policy because trading with an enemy is not permitted. B. Trafficking in public offices. Traffic in public offices is also against public policy. Marriage brokerage contract. This is also covered by the head of public policy. Option D. Contract to do impossible act. This is generally nothing opposed to public policy because it is left to an individual whether he would want to do an impossible act or not. So the answer to this question is option D, contract to do impossible act. Question number 45. A agrees to pay rupees 1 lakh to B if he brings on earth a star from sky. This is a contingent contract, and is this contract illegal? There is nothing illegal about it, so it is not illegal. Is it valid? It is also not valid because impossibility of performance. Is it voidable? No, again this is not voidable because nobody can perform this contract. D. Void. Yes, it is a contract that is void because of not being capable of performance. So the answer to this question is option D. Such an agreement is void. Question number 46. Wagering agreements. It is very clear that wagering agreements are void because they are not permitted and they are unlawful. So the answer to this option is B, void. All wagering agreements are void. Question number 47. Every person attains majority on completion of dash years of age. There is nothing technical in this to explain this question. We should know that a person attains majority once he completes 18 years of age. So the answer to this question is option B, 18 years. Question number 48. Dash does not affect the free consent of the parties. Now, what is the question trying to test you in this? It's possibly listing 4 options: fraud, coercion, incompetence, and undue influence, and wants to understand or wants to check which of these 4 options does not affect the free consent of the parties. In case of a fraud, it does affect the free consent of the party because he is misled. In case of coercion, there is physical pressure that is involved, so there is no free consent. In case of incompetence, incompetence does not have any connection with free consent, but undue influence does have because there is mental pressure exerted. So the answer to this question is option C, incompetence, because incompetence does not affect the free consent of the parties. Question number 49. An agreement to share earnings of a smuggling business is. It's very clear we are talking about an unlawful agreement, and we all know all unlawful agreements are void. So the answer to this question is option B, void. Thus, an agreement to share earnings of a smuggling business is void. Question number 50. A buys an article thinking it is worth 10,000 while it is actually worth rupees 5,000 only. Decide what will be the remedy to A. Now A has bought an article thinking that it would be worth 10,000 whereas the actual worth was only 5,000. This is a mistake which A has committed. The question does not talk about any misrepresentation or coercion or fraud or undue influence. It is A's own incompetency which has led to him buying a particular item at 10,000 instead of actual value of 5,000. So, obvious answer would be that the agreement cannot be avoided on the ground of mistake. So, the answer is option B. A cannot avoid this agreement on the ground that he has committed a mistake in evaluating or in deciding the actual worth of the goods. He has to go ahead and buy the goods at the value at which he had accepted to buy. Question number 51. Dash is a false statement which the person making it honestly believes to be true or which he does not know to be false. If you had read your law concept notes properly, you would get the answer immediately for this, because we are testing the concept of misrepresentation here. Misrepresentation is a false statement which the person making it honestly believes to be true or which he does not know to be false. So the answer to this question is option number D, misrepresentation. Last question, question number 52. Doctrine of restitution does not apply against a. Again, if you had read this question or read the concept notes properly, it very clearly states doctrine of restitution does not apply against a minor. But before we move into that, let us understand what a doctrine of restitution means. Restitution simply means restoration. There could be a situation where a person has done something for the benefit of another person, but there exists no contract between these two people. The court can intervene in such a case and then ask the party who has been benefited to pay the party who has given that benefit to the other person, even though there has been no formal agreement between them. To give you an example, let's assume that a person has built a property or built a house in the property of another person, and this house has been built without a contract between these two persons, and so the owner of the property says that he will not pay for the house that has been built. Despite the absence of a contract, a court can order the owner to pay the builder the cost of labor and materials under doctrine of restitution. However, this doctrine of restitution does not apply against a minor, and hence the answer to this question is option C, minor. With this, we conclude the explanatory session for test number 1, and hope you would have got a fair idea on what a contract is, what consideration is, and what are all the essential elements of a valid contract. Once again, let me reiterate, Indian Contract Act is a very important act that you need to understand it clearly, because it is not only going to be used when you are in CPT, but will also be dealt with quite extensively when you are in IPCC, where the knowledge level expected would be much more than what is expected in a CPT level. At the CPT level, all you need to know is basic knowledge on Indian Contract Act. So if you are clear with the concept notes and you are able to understand the concept behind the questions that have been tested, one can safely presume that you have understood Contract Act to a great extent. Thanks for your patient listening, and wishing you all the very best in your future tests. Thank you.